Hello, this is David Healy with Appleby Healy, Attorneys at Law. Joining me today are Robert Ingold and David Appleby. As you are aware, we have unfortunately had to cancel a large number of our review and safekeeping seminars this year due to the health crisis. So in lieu of getting to see you in person at your favorite restaurant, we are putting together this presentation here today as a video that you can watch in the safety and convenience of your home. This year's topic is, why do you still need a trust in an environment that has a $11.5 million estate tax exemption? As many of you are aware, you may have came in 15, 20 years ago when the estate tax exemption was $600,000 or $1 million, and that was a big focus of your trust planning. However, in 2020, the environment has changed, but there are still many reasons why you want to have a trust and an estate plan as opposed to the alternatives. So the first reason that you would still want to have a trust is you want to avoid probate. Simply put, probate is expensive and time intensive. When I do public speaking and I ask people in the audience who here has been through a probate estate, hands go up, and my follow-up question is, who here would like for their children to experience a probate estate? I have yet to have anybody have their hand up. Nobody wants to go through probate, have their children go through probate. Typically on the timeline, you're looking at 12 to 18 months in what I would refer to as a problem-free estate. The expenses are going to be around 6 to 7% of the total estate. That gets to go out to attorney fees and personal representative fees. In addition, of course, it's a very public proceeding. There's no privacy to it. And at the end of the day, somebody that you do not know, a judge, is in charge of how your estate is finally distributed. Now, there are a lot of misconceptions out there about estate planning and what you can do to avoid probate. Bob, does having a will, does that prevent going to probate?
Well, David, that's a statement I've heard repeated through the years quite often. The idea that having a will avoids probate, when in fact it really does not. In fact, I've sometimes made the statement in reply that a will is a ticket to probate. Now that is an overstatement, but the truth of the matter is that a will has authority only over assets in the probate estate as a general proposition. So what does the probate estate consist of? It consists of basically any property the individual owns in his or her own name at the time of death. If that individual has a will, then the will does govern the administration within the probate court system. If an individual has assets such as IRAs, other retirement accounts, life insurance, which have beneficiary designations, or if the individual possesses joint accounts with other individuals, then those assets are going to pass free of probate, and the will has no bearing on the distribution of those assets.
So it sounds like a will is not the device you want to use to do your estate planning because it's a ticket to probate. So that's another reason why we do want to maintain your trust, is to avoid probate. It's one of the primary reasons. Now, another reason that we want to have a trust as opposed to other things you can do, the second thing that we're going to talk about is what we refer to as TOD and POD designations. TOD stands for transfer on death. POD is an acronym for payable on death. They both essentially mean the same thing. Different entities use those terms alternatively, TOD, POD. The LA Times last year had a great article. I think it was actually on page 1 of the LA Times back in June or July of 2019. It must have been a slow news day to be talking about estate planning on page 1 of the LA Times, but the article was talking about taking shortcuts in your estate planning. And what they focused on was people who were using TOD and POD designations and the problems that caused instead of going to see a lawyer and having a formal trust drawn up that would take out some of the wrinkles of those transfers. So, and typically speaking, a lot of our clients probably do have TOD and POD designations at our suggestion for certain assets, but these are typically going to be smaller assets, or for tax reasons that we make those suggestions. we would certainly never encourage you to devise your entire estate using TOD or POD designations due to the problems that causes. David, talking about TOD and POD, are beneficiary deeds a good idea?
Well, it's not something we would generally recommend in terms of an estate planning tool other than to fund a trust. That said, you know, the TOD, POD, beneficiary deeds are all part of the Non-Probate Transfers Act. Sounds good, non-probate transfer. The problem is that it doesn't always avoid probate. So that even though it's lawful, certainly something you can do, the bottom line is, as often as not, it simply doesn't achieve what you're trying to achieve with your estate plan. And here's some examples, and Dave and Bob know, and frankly some of you watching know, I've got about an hour seminar on this very subject. I'm going to try to summarize that into just about 60 seconds here. But among the problems are, if you delegate authority, or I'm sorry, you designate a beneficiary, and that beneficiary dies before you, then you have no beneficiary. This can happen with life insurance too, incidentally. And then we would have a probate asset. It's sometimes even a worse circumstance is you designate a beneficiary, and that beneficiary at the time of your death is incapacitated or disabled, what we used to call incompetent. That could trigger a probate for the beneficiary, not necessarily in your circumstances. Another thing that people sometimes try to do is use the beneficiary deed to transfer to children, for instance. And perhaps it's a second marriage, maybe not, third marriage, but it doesn't really matter. They try to use the beneficiary deed to transfer assets to their children. That does not negate or do away with the right of a spouse to have an interest in the property, and people typically misunderstand that. Another issue, of course, is creditors. People always kind of smile and think, well, we never thought about it this way, but you know, you can't die to get out of paying your bills. The probate code and the trust code both have provisions where you can publish in a newspaper, and at the end of 6 months, the time that creditors could file a claim terminates. But unfortunately, the Non-Probate Transfer Act doesn't have such a provision. So that in terms of creditors, not only can creditors come against that property to satisfy the indebtedness, but they have 1 full year from date of death. So actually, what would seem like a simpler way of transferring property, perhaps with a beneficiary deed, can actually wind up a much longer period of time before the beneficiaries can actually receive the property. And because of that, incidentally, that can cause problems in terms of title insurance. If you receive the property and you want to turn around and sell it, and the 1 year hasn't already transpired, then it may be difficult to get title insurance to sell the property because there's the possibility of those outstanding claims. Whether there are claims or not is not the issue. The fact that there could be during that 1 year time frame can cause you title insurance problems. And then, unfortunately, I know we all know this, and you don't have to be a lawyer to realize that families are simply more dysfunctional than they used to be. Certainly more dysfunctional today than they were 45 years ago when I started to practice law. The end result is if you name 2 or 3 or 4 children or other beneficiaries, and all the other things go just fine, and so now you die, they're all living, okay, that sounds good, except that now to transfer that property further, you're going to have all their spouses. So we might have as many as with 3 people, maybe a committee of, or 3 beneficiaries, a committee of 6. Well, in dysfunctional families, sadly, it may be that at least 1 of that 6 or 2 of that 6 may disagree about the sale price or what else has to happen. And unfortunately, while that doesn't still result in a probate case like these other situations I mentioned, it can result in what's called a partition suit, where children or the other beneficiaries, if they're not children, wind up suing one another, and the property then winds up being sold on the courthouse steps. And I think we all would believe, and I think it to be true, that that's not the best way to dispose of estate property, is having a sale on the courthouse steps. So, as I say, do beneficiary deeds have a place? They do, to fund the trust, because the trust is not going to die. The trust won't be incompetent. So basically the issues that we're talking about, if, for instance, if we made a recommendation that your checking account still be in your name, but pay on death to the trust. That's to give access to the agents under your power of attorney more conveniently. But then at your death, it immediately goes to the trust. Same thing with vehicles. There are reasons that we won't get into too much detail here, but it's to your advantage if you already own a vehicle to just keep it in your name and have it transfer on death to your trust. And again, that would give the agents the authority to sell the car if you went to a care facility or otherwise couldn't take care of that yourself. So beneficiary deeds do have a role, but it's basically in funding a trust. As a standalone estate issue, I think we continue to suggest that, to answer your question, no, that's not a good idea.
Well, when we talk about TOD, POD designations, typically what some of you may have heard in my office talking to me are that there are no real shortcuts, there are no easy solutions here. Typically, every shortcut you take is going to have a corresponding pitfall, as David just talked about. A lot of things that we don't think can happen will happen. Unfortunately, those are the phone calls that we tend to get here that they have happened. And obviously, once you're gone, there's not a whole lot fixing it other than going to the court to fix it all. So we kind of talked about we still want to have a trust to avoid probate because a will is not going to help us out there. And we definitely want to have a trust as far as it's a better way to convey assets than a TOD, POD designation. A third reason, and another reason that we still want to have a trust, is because of the detailed planning we can do with a trust. Each of our clients and each of our clients' families are unique. Every trust and estate plan that we draft here at Appleby Healy is going to be unique to your family. It's not just a cookie cutter form. So having that trust document to be able to address your unique family needs is imperative. So one of the things that we always focus on, and we're always going to talk about, and is in each of your trust plans, your estate plans, is how do we protect beneficiaries? And Bob, would you like to address some of how is it that a trust can protect a beneficiary, whereas a TOD, POD, or will would not?
Well, if you have a situation where you have minor beneficiaries or incapacitated beneficiaries, beneficiaries who are going through a divorce or bankruptcy or liability lawsuit, any of those situations would be occasions where it would not be wise to distribute a large sum of money just outright to that individual without any restraint or restriction. So the trust gives you the ability to control the timing and the manner of distribution to the beneficiaries within certain guidelines that the individual client would establish. So, for example, we've had cases in the past where beneficiaries have been going through bankruptcy or divorce cases at the time of the settlement of the trust estate. And there's the possibility that those estate benefits would have been entirely lost had they been distributed to those beneficiaries. So the trust gives the flexibility to retain those assets within the trust until the legal dust settles, so to speak, and then distribution can be made at a later time. Another important flexibility feature to the living trust is that it allows for charitable distributions. It allows for designations of gifts to go to specific charities rather than making piecemeal designations through some kind of attempted transfer on death plan or a lifetime giving. This is a method whereby an individual can designate gifts to charity and leave it up to them, to the trustee, to carry out the directions to fulfill those charitable commitments. And so the living trust does provide a comprehensive way in which to manage the assets of the trust estate in a way that does protect the interest of the trust beneficiaries going forward.
That's a great point, Bob, too, about just the comprehensive nature of a trust or estate plan. It's not unusual. I'm going to have a client come in and we talk about this. They have multiple assets, and if they're currently relying on a TOD, POD type gifting strategy or distribution strategy, every time they make a change, they have to go talk to 6, 8, 10 people to make sure that their changes are affected. When you have an estate plan and we have all the assets pointed to one living instrument, the trust, at that point you just have one set of rules that applies to everything. So if you want to make a change, it's a very simple procedure where you make a change in your trust documents, and that applies to all of your assets because they are all titled to your trust. So another, maybe I wouldn't say a strategy because it's not really a strategy, it's a shortcut. Sometimes clients come in and like to discuss with us, and we certainly understand where they're coming from, is what we refer to as give it away now. So that means basically, let's forget all this estate planning stuff and let's just give it to the children or our beneficiaries now while they can enjoy it and we can enjoy giving it to them. And they're going to be nice to us and they're going to let us continue to live in the home. There won't be a problem, things of that nature. There's obviously some fundamental issues there that we want to discuss. Even families that are tight and get along well, and we're going to say we're going to just give the family farm to our son because he is currently running the farm operation and he deserves it. At the end of the day, you still have to be very cognizant that you're losing control of these assets. So it may not be necessarily the relationship with your child that comes into play. It could very well be a third party. So some of the things that we talk about with TOD and POD transfers come right back. What if that child goes through a divorce? What if that child is in a car accident, doesn't have sufficient insurance? Now they're foreclosing on that property that you're living on, maybe due to no intentional direction of anybody other than that's what happens when it's not in your name anymore and you have it titled in the name of a child. Outside of kind of those practical considerations of being understanding and clearly understanding when you give your assets away, you don't get to ask it back later, and if there's a problem, you've given it away, you can't go back and fix it. There's actually a statute in Missouri about fraudulent giving where if you have given an asset to somebody and then they get into trouble that they try to give it back to you, and that doesn't work. It's not allowed in Missouri. There's potentially a bigger problem with the taxes that can be generated from that type of transaction. David, what type of tax liability can be generated from this give it away now strategy?
Sure. Well, in 1979, Congress enacted the tax basis rules as part of the Internal Revenue Code. I'm surprised when people come to see us, they're concerned about taxes at their death. And really there's not much of an issue there because, as Dave's already explained, the vast majority of people are going to be below the exemption, don't have to worry about the federal and state estate tax. And of course, hadn't been said here, but you may be aware in 1977, the state of Missouri got rid of inheritance tax. So for most of our clients, there's not going to be any tax when one or both of you die. However, in an effort to do something that perhaps your parents or grandparents did, just give it away now, you can create a tax because the rules, there's nothing simple about the Internal Revenue Code, but as simply as I could state it, if you transfer something during lifetime, it has the low or carryover basis, meaning what you can prove your parents or whoever left it to you paid for the property. Sometimes that can be difficult, by the way. If something's transferred 2 or 3 times in your family, the family farm, for instance, or the family business, it's kind of hard to determine what that basis might be. But that basis then is what's used to determine what, if any, tax is going to be due. And if you sell the asset, and then you're going to have to pay income tax on the difference between what you sold it for and what you can prove your parents or grandparents paid for the property. Just a quick example, if you paid $100,000 for the property and 25 years later, it was given to you 10 years later, and 25 years later you go to sell it and you sell it for $200,000. You've just made, for income tax purposes, $100,000. Well, the cap on capital gains is 20%. State is, it's federal. State is 6%. You throw in the 3.8% Obamacare surtax for that being a passive gain to you, by the way. You see we're right at 30%. So on a $100,000 gain, that's $30,000 worth of taxes. There were no taxes just because you died, but there were taxes based on when you transferred the property. Now, if you go through probate, and we're talking about avoiding that, but if you did, it would be the same result. But if it's in the trust, okay, it's going to transfer to your beneficiaries after your death. And under those same 1979 rules, then your beneficiaries get something called the step-up basis to value as of date of death. So if it's worth $200,000 at your death, and it transfers to your children after your death, and they sell it for $200,000, then they don't have to pay any income tax, because the difference between the step-up basis and the sale price is zero, and 0 times whatever the tax rates are going to be is still going to be 0. So even the probate expense, typically, if you've owned real estate for any length of time, even in the probate expense is going to be less, but certainly it's going to be less expensive for your family to keep that in the trust and not go ahead and transfer it right now.
Okay. So there's a lot of reasons we don't want to use, and I think maybe errantly just refer to it, a strategy. It's not really a strategy, it's a technique, I would say. So the give it away now technique has a lot of traps in it as well. It seems like an easy solution. And back to what I said earlier, rarely do the seemingly easy solutions actually work to the benefit of your beneficiaries. Typically, the cutting corners today results in more of a liability down the road. So that kind of concludes the presentation part of why we still want to have a trust, why we want to utilize revocable living trust, even in an environment where estate tax isn't the biggest issue we're dealing with. Now we have a few more topics we're going to talk about very briefly here. One of them, of course, is number 1 on the Review and Safekeeping letter this year, the Secure Act. That was went into effect. It was passed by Congress back in December. The President signed it on December the 20th of 2019. It is now the law of the land. And I go into a little more detail in the letter. Just want to follow up kind of a brief overview of this act. Probably the biggest thing I would like for the clients to know is that it does not directly affect a lot of you. Now, it certainly has changed a lot of the rules. It will affect you in one way or the other. But as far as needing to immediately change your estate plan, certainly please come in, talk to us about that. But it is not a situation where I have a lot of concern that there's a large effect to the majority of my clients and everybody just needs to run in immediately and do an amendment. I don't really see it that way. The biggest things to be aware of is that it does change, of course, the date that the required minimum distributions start. That's now age 72. And the lifetime payout, what we would refer to as stretching the distributions out, no longer exist. It has to be fully distributed within 10 years and all taxes paid. Obviously, I would tell you that a majority of our estates, rarely did we stretch more than 10 years. Certainly there were some that we did, and that's going to be very, very large tax-deferred accounts that we want to spread the tax burden out for. But that's a small minority of clients. And I'm just kind of summarize that by saying if you have concerns, please feel free to call, come in. We're happy to talk to you about it. But it is not an issue that I feel is, I'm going to say, should cause you to be laying awake at night worried about right now. It's just affects a smaller percentage of our clients. Now, one thing I would say in addition to that, and I'm getting ready to segue back to David and kind of our current national health crisis here. Congress has passed a number of laws here just in the past month. So sitting here today in Ozark, Missouri, April 2nd of 2020, we have just had a rush of legislation that's been passed in Congress. One of those is the CARES Act, and part of the CARES Act addresses a lot of financial issues in the country, is there is no required minimum distribution for 2020. So that just happened here in the last couple of weeks. So that's something you definitely want to talk to your financial planner or your CPA about. You still may want to do it, but there is not a requirement for it to occur in the year 2020. At this point, I'm going to segue back to David just to briefly address what is going on here in our country today.
Well, there's so much on the news. Frankly, for me, it's very difficult to sort out. It's clear that we have a worldwide crisis. And just kind of narrow that down all the way here to 119 North 2nd Street in Ozark, Missouri. Let me tell you what we're trying to do in light of all of this. Our door is still open. Our sister companies, they're all, along with our law firm, are all essential or designated essential businesses. So we're still open for business to protect our staff and to protect you. Okay, we're trying to do everything that's been recommended. We're social distancing. We're trying to do more of our consultations that don't require signing of documents, for instance, to do that from the safety of your home, and we simply talk on the telephone. I'm going to say in the last 2 weeks I've done more teleconferences, if you will, with the clients than I probably would do in 6 months. So most of you are calling in, and we're happy to do that. That's not always as easy as it sounds, but we're making every effort to do that. We've tried having employees work from home, so we're not as crowded here. We have, in our offices, we have people, again, social distancing, so our staff is spread out throughout the building, so that we do that. When you come to see us, incidentally, I've got a new habit, but between clients, or even if other people's staff or lawyers come in the office, when they leave, I get out my this is not an advertisement for Clorox, but my Clorox orange sanitizer wipes, and I wipe down the entire desktop, all the arms on the chairs, even the pins and the door handles coming in and out, and then I run downstairs quickly because I've run out of sanitizer in the office, but I run downstairs real quick and do a squirt of that. And of course, when you come in to see us, we're not shaking hands. Personally, I feel a little silly bumping elbows or fist bumping, so we just say sorry, we can't shake hands. But we're doing everything that we can. Certainly, if you feel sick, please call us and cancel your appointment. If we can do it by phone, with just a phone discussion about maybe an amendment, and I think that's what we're seeing. Certainly, I'm going to say an increase in the phone calls we're getting where you're saying, I'd like to change my plan. You're not coming in, you're simply calling us. That works out well, and then we can schedule you a time to come in and sign up, but you're not here very long. And you can do that on your way to the grocery store or some other essential trip that you have to make. You can run by and you can get those things signed. So, like you, we're hopeful and we're praying that this is not going to last that long, and that maybe we're seeing the worst of it right now here in the next few days, as I understand it from the news. I don't know if we'll ever get back to what we'd call normal, because everything like this changes our lives forever in some way. Maybe we're just going to wash our hands more than we used to, and maybe we're going to shake hands less. I don't know what all the implications are. But again, we're doing everything we can to protect you and protect our staff, and yet continue to be here and provide those critical legal services to all of our clients.
Thank you, David. And yes, I think this is clearly going to change all of our lives forever. I think we're all going to be more cognizant going forward of how viruses are spread and sanitation methods. In addition to everything David talked about, the reception area is being sanitized 3 to 4 times a day. It's it's kind of every time a set of clients leave, we're sanitizing everything, doing our best to do our part. We are an essential business, and we want to be available to you. We understand a lot of people have concerns right now about making sure that their estate plan is exactly the way they want it, that they have all the documentation in place. So we are available, and we appreciate your patience of working with us, as we are doing a lot more of this by telephone and briefer meetings. So that's kind of the heavy part of this for a moment. So Bob Ingold is going to lighten things up now for us. And a lot of you have mentioned to me that you missed the lawyer jokes on the RSK documents last year. And I'm going to work at being funnier. But in the meantime, I've got Bob Ingold here to rely on, who is going to have this year's lawyer joke.
Okay, David. Well, thank you. This is a serious time in our nation, and we're certainly concerned about each one of our clients and your loved ones and the things that you're going through. But I think it's at the same time good to maintain a sense of humor, and occasionally a brief injection of humor helps improve morale a bit, and it lightens the spirits. So I'm going to attempt a little humor here this morning. I have a qualifying statement before I give the joke. This is what we refer to as a lawyer joke, but we want to clarify that we're referring to trial lawyers. We're not talking about Mr. Appleby or Mr. Healy. We're referring to trial lawyers. And don't tell any of your trial lawyer friends that I've been talking about them, but I've got a question for you. What is the difference between a lawyer and a mosquito? Well, one is a blood-sucking parasite, and the other is an insect. Drum roll, cymbal crash.
All right, very good. Bob, thank you for the always appropriate lawyer joke that is not clearly about us, though we clearly do have a sense of humor about what we do for a living. We don't take our professions that seriously. In concluding remarks, I'd just like to say thank you very much for being a client of Appleby Healy. We sincerely appreciate that. We take our responsibilities here seriously. You're very important to us. It is our goal to make sure that you have your needs met, and that I always tell people my biggest goal when we finish a meeting is that you don't have any questions. We want you to be comfortable with the documents that you have and the plan that you have. But during this time, we also want you to know that we are available to you. We miss seeing you at the seminars. That was always a highlight of getting to see people at least once every couple of years and just catch up. We have grown somewhat close to some of our clients. A lot of our clients we have done work for many years, so we miss seeing you at the dinners this year, and we hope to see you next year. Thank you very much.